Thanks for joining us. It's live with Miami's Community News, and our guest today is the Honorable Dexter Lehtinen, who was a former U.S. Attorney, Southern District, and there were 200 plus lawyers in that office. And most recently, he was the city attorney for the village of Palmetto Bay. And correct me if I have it wrong, you served 3 mayors, 2 managers, and 2 clerks.
Yes.
So
during that time,
you have a lot of experience.
well, we were there 5-6 years.
Yes, and you've been practicing law for a while.
Yes.
We won't suggest how long that is, but it's been a while.
No, it's been a while. 75.
Right.
California and Florida and other places.
Right. So you're privileged to be able to work with the citizens and the management of the Palmetto Bay in many years, including in 2017. And there's a question most recently about a land purchase that was made by the city by the village. And what were some of the issues then, and what are some of the issues that have come up most recently?
Well, the issue then was that prior to my being village attorney, an owner of 5+ acres had won litigation that allowed them to build a charter school. They then went forward, and by 2017, they had the necessary approvals to build on a charter school on what was called the school site, 1 acre, actually 0.98 acres, but we'll call it 1 acre. And that charter school, as my recollection is, was substantially opposed by a lot of residents. Now, the policy merits there are up to the residents and the council, but there was strong opposition to the charter school on 1 acre. That's how the issue began. Particularly as all of the studies were done about the traffic problem, the stacking of cars going back onto Franger Road and so forth like that. And there were lots of efforts made in the design to keep that from happening. But the point is they had the right to build. So the idea developed that if that school site could be bought, but not just that school site, you would have to also buy a restrictive covenant for the rest of that acreage, for the 3+ acreage that would remain. And if the village bought it, it would need also the road access.
So the inquiring minds want to know, if they could have built the school, how many students would they have?
That school was approved for 1,100 students.
That is a lot of kiddies.
That's a lot of kids, and that's a lot of cars. And as one looks back, it's still surprising, how that litigation was won, but that preceded everybody more or less involved in the controversy. They won that court case, and they had approvals to build for 1,100 kids on 1 acre.
Most of the people in Palmetto Bay, that was a rallying call against that and pushing the commission.
Yes, from the political viewpoint, the council people were pushed to find a way to block the school. Of course, the first effort was to deny it, and that was prior to my time as a lawyer, and lengthy litigation ensued, and the owner won the litigation. So all legal efforts to block the school were a failure. So the only option would be to buy them out, and that would mean not just buying out the 1 acre, but buying a restrictive covenant on the on the remainder of the property. And then if you bought the 1 acre, you wanted access to it, because the unitary owner of the property would no longer have an interest in access to the back. So the proposal was to buy 3 things. 1, a restrictive covenant on the remainder, whatever value that is you put into the
on the remainder
on the remainder of the property, the 3+ acres that would remain. The second was to buy the school site, and the third was to buy the access roads to the school site, for which the village was later reimbursed $800,000 from general obligation bonds of the county. So they paid 2.9, and 800,000 was paid with reimbursed with bonds. So it cost the village 2.1.
So that's in the negotiation with the property owner. You purchased the 1 acre. It came with the right of way. And then also there was a covenant on the remaining land, so there'd be no charter school put up anywhere out there.
Right. The right of way is added to about 1.29 acres, and the school was 0.98. So the whole thing added to 2.27 acres, but also that would have been of little value without paying the property owner and buying a restrictive covenant on the remaining 3+ acres. So like I say, the judgment as to what value goes where, that's purely a judgment. How much does it take to get the restrictive covenant? How much does it take to get the 1 acre? How much does it take to get the access? The total in the end was 2.9 something, and the council decided to do it.
So the access road right away, whatever, that would be an open road where people in their cars could go up and down the road.
Absolutely.
And maybe service whatever.
That was a road that would, from the viewpoint of the policymakers, give both access to their 1 acre site, for which some plans were actually developed for a community center. There was also talk about, other people have community centers, other villages like Pinecrest. Why don't we have a community center? Again, that's all the judgment of the policymakers, not the legal. But legally, the city got everything that it, we say city because that's the legal status of the village. The village got everything that it bargained for. And that's clearly available in documents that were always available to the village council, were available given to the village attorney actually the same day if he didn't know how to find them. And
when you say the same day when recently or
yes, I think it was April 5th, if I recall. The council passed a resolution which actually in the end asks for an investigation, but has a lot of innuendo in it as to it would appear, quote unquote, that the village did not get what it bargained for. It would appear that the property appraiser's website, why you go to the property appraiser's website and not your own deed is beyond me. If I want to know what I own, I read my deed. I read my recorded deed, my provable deed. If I want to know whether it's what I got, what I bargained for, I match the deed to the resolution. And of course, the deeds have these lengthy legal descriptions, but the resolution itself says we want to buy 3 things. It says the school site, it says the roadways property, and it says a restrictive covenant. So if you take the exhibit attached to the resolution as to what they wanted to buy, those are the 2 fee simple, which is complete ownership, as opposed to a restrictive covenant, which is a lesser form of property right, but it is a property right that you pay for. You take that deed and that description in the resolution, and while you don't have to do it word for word, you just take it and you look at your deed, and you know how as a kid you can put it up to a light, one piece of paper, another piece of paper, and you see it's the exact wording. It doesn't take a rocket scientist to see that the deed, the recorded warranty deed, has the exact same land description as the resolution asks for. And then there's a restrictive covenant, which is recorded and which is in the village's records, which restricts the rest of running to the village in the village's name, that restricts any school construction on the remainder of the property. We mean private school, charter school construction on the remainder of the property, not technically private, but charter, which is technically public. And then there's the survey. There's the survey records, which are in the possession of the village. And the surveyor says, here's the survey, and has the map on the 0.9 acres. He calls it the school site. He said, here's the survey on the roadways. And that survey, he signs the affidavit saying that this is exactly what matches the resolution.
So it appears what you're saying is the city purchased the almost 1 acre. They have the right of way,
right,
and they have a covenant on the rest of the property, so a charter school cannot be put there.
Right. So of course, we call them a right of way. Technically, they own it. Yes. Right of way is is the way people commonly refer to roadways, but somebody owns the underlying.
The city.
And in this case, the city owns it. Sometimes a road is built on private property with the city owning a right of way. But in any event, yes, to block the school, and or in addition to get a community center, but initial thinking was to block the school. They bought the 1 acre school site, which is labeled the school site in the resolution authorizing the purchase. They bought the roadways, which are labeled that way in the face of the resolution authorizing the purchase. And they bought a restrictive covenant prohibiting schools on the remaining 3+ acres. And for that whole thing, they decided to pay 2.9. The seller would not sell for less. The seller wanted to sell the two properties and not the restrictive covenant, but from my viewpoint as their lawyer, if they didn't get the restrictive covenant, they were not going to block a school. So they got all three: school site, roadways, and the restrictive covenant on the remaining property.
And right now, the current city manager has this, because you dropped this off, showing him all the questions that were asked at the last council meeting.
Yes, the city manager was, not involved in the transaction, but they direct him and the village attorney to, quote, do an investigation. So he has all of these documents, and I'm of the belief that both the city manager and the village attorney, John Della Gloria, Mr. Della Gloria, would look at the documents and see that they got exactly what they bargained for. Whether they want to sell it back or risk a school being built on that site now politically, that's all up to the policymakers. But it is not it's not an appropriate form of behavior to imply impropriety when what you actually seemingly want to do is object to the policies decisions that were made. And if you were to sell it back, by the way, the seller offered to have the village sell it back to him, and it was rejected by the council, including members of the council who had voted no on the original property purchase. They decided, I guess, that blocking the school was worth it.
So as far as for the current city attorney and the current city manager, they can take your documents there, go verify them wherever they need to verify them, and it's a pretty short investigation, because we know what the city negotiated for, what they got, and now it's going to be just to verify that.
It's a pretty short investigation, because a long time ago, we're not like in 1800 when you went and staked out land in Kentucky and that had problems with your deed. We record our deeds. And everybody does, for the last several hundred years. The deed is recorded. The deed has the property description. It's the identical attachment to the resolution that authorized it. The resolution refers to a school site and roadways, and then the restrictive covenant is also recorded. The idea of saying, gee, I'm confused because I looked on a property appraiser's website, that's a method of avoiding the truth and not wanting to seemingly, in my opinion, not wanting to actually have an answer to the question, wanting to pose the question, leave it hanging in the air, and not seek an answer, because anybody can get an answer to this very quickly. But you don't go and ask the people who can give you the answer. You don't go and look at the documents to get the answer if you don't want the answer. In my opinion, the answer was far less important to one or more council members, in my opinion, than posing the question and leaving it hanging in the air. That's what causes me to go visit the manager and say, look at these documents, so that this does not continue.
So you said you visited him last week?
Yes.
And you brought him this? And
yes, and Mr. Della Gloria, I don't mean to exclude him, but I know John. I had never met the manager, John being the village attorney. I had never met the new manager, a former Marine. My kids are Marines, so I took this occasion to cover that.
So right now, the city's going to finish their investigation. You supplied some of the documents they need. They can look and see what they agreed to buy, right? What they got, and to verify that the city, what they purchased and they received that. Right?
That's correct.
And let's go over again. They got the covenant.
That's correct.
On the remaining property, they can't put up the school. They own what's called the right of way that's between the property,
the roadways,
and then the almost 1 acre where the original school was going to go with the 1,000+ students.
The school site. Right. That's correct.
So it's at this point, it seems to be pretty simple, and hopefully there'll be a public announcement soon at the next perhaps at the next Village of Palmetto Bay meeting.
Well, I would hope so, and I would explain that to the village council as well, and I would hope they would indicate that that their questions were answered correctly, and that there is no reason to believe that any of those whereas clauses, most of them, one of them is just the whereas an acre is 45,000 square feet or something. Okay, that's accurate, but that the council or the attorney or the manager would say that they've looked at it and there is no issue in this regard.
And so I just want to go over again that you were instrumental in putting this together.
Well, I was the attorney who reviewed the documents, made sure they got what they bargained for, and so forth like that. Putting it together, that's a question of the policy, but legally, yes. If there's something wrong, well, we hired a land expert lawyer to do the closing documents, but if they didn't get the school site and the roadways and the restrictive covenant, then someone should look to me as to why they didn't get them. On the other hand, they got them, so somebody should have looked to me as to whether they got them as well.
Sometimes people don't understand why city or county attorneys may sometimes hire an expert at a particular venue. Why is that?
Well, that's because when you prepare the deed and you record the deed, you want a real property lawyer. The negotiation of the contract is not done by that real property lawyer, but almost every lawyer I know hires a lawyer to do the closing, to actually prepare the documents that then end up with the stamp of the recorder's office, to prepare the restrictive covenant.
Right.
Now, those are reviewed by the primary, by me, but every time my law firm represents somebody in a real estate closing, we use a real estate lawyer to prepare the actual documents and to make sure the recording is done correctly. There's been no question about whether this recording was done correctly. Actually, there's been no question about the deed at all, because in the course of making the inquiry, apparently nobody bothered to look at the deed, which is, of course, one of my points here. You should read your deed before you claim you don't have a deed.
And some folks think if you go to a lawyer or a doctor that you're good. It's especially if you go to your general practitioner and he says, I think he had a cardiac problem, he would say you need to go to a cardiologist.
Absolutely. The general practitioner doesn't do the colonoscopy, and he doesn't do the heart work, and he doesn't do the eyes.
Right. It's just the way.
Trust me, I've got a number of specialists carried over from the old war wound, so to speak, and every one of them has a specialty, and that's true in law. You don't want to have a non-real property lawyer prepare the deed. You have a non-real property lawyer work on the question of the negotiations and representing the village and saying to the village, look, if you don't get a restrictive covenant, don't bother to buy the land, because you need a restrictive covenant. You need that form of property ownership in addition to the two fee simple, which is complete ownership of the two parcels. That you expect your lawyer to do, but you expect your lawyer to get an expert to prepare the deeds.
As we wrap this up, do you think there'll be a time in the near future that you might be asked to go before the village council? And
that would be my pleasure.
And that might be a good thing if the city decides, village.
Right.
Decides,
and I think that would be quick. There'd be no need for any controversy in that.
That sounds good to me.
Unless someone wanted it.
Right. Well, I don't think anybody wants any more controversy with the village of Palmetto Bay, do we? So I think we're going to wrap it up.
Thank you.
Dexter Lehtinen, is there anything else you'd like to add?
No, that'll do it. Thank you.
Right.
It was a pleasure to be their attorney, and it's a pleasure to have moved on, not because of Palmetto Bay, but there's a time for everything in life, and
Yes.
I enjoyed that work, and now I'm enjoying not doing it.